Oscar, were you able to get him? Okay. All right, ladies and gentlemen, welcome to today's lecture. Today is a continuation of the final provisions. Remember, we said every bill has four parts: preliminary provisions, principal provisions, miscellaneous, and final provisions. So we're dealing with the final provisions. If you check your chart box, you will see the components of final provision. First of all, what are final provisions? It's a part of the law, the concluding section of any legislation. It addresses transitional matters, repeal of existing legislation, consequential amendments of existing legislation. Now, what is the purpose of, why do we have uh, final provisions? The purpose, one of the purposes is to create legal consistency. Legal consistency. That is, this new law must fit into the existing law. Nigeria has 552 laws as of 2004. We had 552 laws. So anytime you draft a new law, the new law must not conflict with existing law. So what that means is you need to look at the 552 laws of Nigeria to make sure that none of them conflicts with the new law. If there's a conflict, two things can happen, which is part of the final provisions. There are two things, two areas, two subheadings under the final provisions where you deal with that. One of them is called consequential amendments. The second one is called repeals. Consequential amendment means that you are amending sections of existing law to suit the new law. Consequential amendments. So that part of final provisions where you amend existing laws to suit with the new law is called consequential amendments. There may be many laws that are affected.
Good afternoon. Good afternoon.
Maybe up to 100 sections of any new previous laws. So what that
Well
means,
done, sir.
please, Abdullah Hisani, please mute your mic.
I just passed second reading. The technical amendment.
Okay.
You have the details.
Please,
Some of
Abdullah Hisani, can you mute your mic,
can you
please?
please help me with it? Some journalists are requesting for it. Okay, but send it to me now.
Prof, you can mute him from the back end.
No. It has passed second
Prof, you
reading.
can mute him.
Okay.
So what?
All right. So I said consequential amendments may be more than 100. And when that happens, you need to create a schedule of all the consequential amendments. Then the other thing that could happen is called repeals under final provisions. Repeal means that the existing laws are repealed for the sake of the new law. So you have to provide a list of all the existing laws that are now repealed because of the new laws, the new law you are drafting. So take note. Ebenezer, you can take over.
Thank you, Prof. Thank you. Good afternoon, gentlemen. Trying to solve a network challenge. Mr. Austin, I will blame you for today's honor. You have not done the needful. Okay, welfare provisions. We have dealt with the first three: preliminary, miscellaneous, preliminary, principal, miscellaneous, and final. As we already know, final provision refers to the concluding section of the law. It's just the concluding part. What concludes the law? If you had preliminaries, just common sense. If we had a beginning, if we had the initial part, if we had the starting part of the law, we should also have the ending parts. And what does final provision do? It itemizes certain aspects. One, savings clauses is in the final provision. What are these saving clauses? It preserves, if it is job, if it is property, if it is existing law, if it is existing portion of some laws, or the law that is being amended, let's us assume it is an amendment act, it preserves some parts. One, consequential amendments amends not just the one you are amending, but if by reason of your current amendment, other sections in different laws are affected, then you now put it in the final provisions that section A, B, C, D of a different law entirely is hereby amended by reason of this amendment I am making here. Then repeal of existing laws. I cited the example the other day. You might be repealing an existing law, but where you are doing, let's say a law has 30 sections, and you're amending
All right. Can anybody hear? Can you hear me? Please confirm.
Yes, Prof. I can hear you.
Okay, so what he was saying is consequential amendments, if there are many, more than 10, you need to create a schedule. A schedule is an appendix to a law. So you create a schedule to that section of the consequential amendments. In that schedule, you list all the laws, existing laws that have been amended because of this new law. It can be up to 100. Your duty is to take time. And by the way, I was impressed. Somebody sent the assignment. They did the arrangement of clauses. Once you have gotten that right, you can do anything. Your bill will be very good. So your schedule to section of the transitional provisions, consequential amendments should show you a list of all the existing laws that have been affected by this new law, and then you list them. The same thing applies to repeals. Under final provisions, repeal is another section. So if the laws that need to be repealed are even up to 50, you create a schedule and list all of them. So that's the consequential amendment is, final provisions are very important because that's how you create the harmony between existing laws and the new law. So it's a time consuming, for Lesotho, they have 16,000 laws in the current index of laws of Lesotho. 16,000 from 1800 to 2024. So it means if you're drafting any new law in Lesotho, you have to look at that index of 16,000 laws. But the good thing about the index is published by LexisNexis, well arranged. You have historical index, you have subject matter index, then you have chronological index. So everything is well arranged. So you see through the index whether there's any existing law that is on the same subject matter as what you are drafting. Then you have to deal with the final provisions, such as consequential amendments and then repeals. So it's very important you look at this. Very important. Now, for Nigeria, I told you our index is not so tidy. We have 552 laws as at 2004. 2004. That's 20 years ago, or 21 years now. Now, between 2004 and 2025, we have had the count I did was 344 laws. So if you add it to 552, that should give you something. So it's important you look at every one of those laws to make sure there's no conflict. In Nigeria, I'll give you an example. Because drafters do not look at previous laws, Nigerian National Assembly passed a law twice. The ICPC Act has two laws. One was passed in the year 2000, the year 2000. Then in the year 2003, the same law was passed again by the National Assembly, and none of these laws has been repealed. So you have a situation where lawyers are taking advantage of it. If you charge somebody under the ICPC Act 2000, the lawyer will raise preliminary objection that you're supposed to charge him under 2003 version of the law. So they'll just be playing with the courts. That's why the ICPC is not so effective as an anti-corruption agency in Nigeria. They still have not repealed, the National Assembly has not repealed that law. So until it is repealed, this confusion will continue. So that's the reason they passed the law. They forgot because they did not check. The drafters of the 2003 version did not check the laws of Nigeria. So they passed a law that had been previously passed before. So it's very important for your legal system. If you're drafting any new law, you look at the existing laws. Because some laws are, let me tell you what some lawmakers, when they sponsor private member bills, they will go to the National Assembly clerk. They will look for the old laws, the previous parliament, the legislators that did not win election to come back. Some of the bills they sponsored, these new ones will go and pick them up and start sponsoring them. Meanwhile, maybe some of those laws were passed and you didn't know because we don't keep good records. I said Lesotho has an index of their law 2024. Nigeria does not have. So you don't know which laws have been passed or not. So it creates problems. Sometimes you can pass a law twice. Yes, Ebenezer, carry on.
Thank you, Prof. Sorry, my internet is fluctuating. Mr. Oscar, we have to solve this problem today. So I was saying that the NFIU was a unit under EFCC. So, and the EFCC Act, one of the sections provides for NFIU. So when NFIU became a separate agency, there was need to repeal the section of the EFCC Act that recognized NFIU as a unit under EFCC. So that becomes he will repeal that particular section, recognizing NFI as a unit under EFCC. So the session would totally be repealed. Now, if you want, you can amend that section to read that NFI is now a unit, a separate unit, but that will be of no moment. So what you do as you're doing law revision and rearranging the sessions, you just remove that session entirely. So you see that it is possible because it was existing under the EFCC Act. You have now given it its own life to stand as a separate agency. So you make a consequential amendment by reflecting that. So when we say it ensures that if any one part of the law is invalid, the rest of the law remains enforceable. So you will not say because we removed the section that created that recognized NFIU before as a unit under EFCC. So the entire EFCC Act becomes invalid. We will continue to enforce the other parts that are not affected at all. Then, transitional arrangements. It outlines how existing situations or ongoing activities will be handled during the transition period to the new law. For example, if Agency A is being subsumed into Agency B, and Agency A already has contractual relationships with people. Agency A has employed staff under its name as Agency A. They are under the payroll of Agency A. Now that we are merging Agency A and it is being subsumed into Agency B, what happens to the contractual relationships that Agency A has with people? What happens to the employment of all the staff of Agency A? Should they go home? The answer is no. So what you do is you first save, you preserve the employment of all the staff of Agency A, and you now transit them into Agency B. That all the staff and Agency A, their employment, their salary scale, and all that are hereby saved and preserved. Yes, Professor.
It's not only staff, you preserve assets and liability. For example, contractors who supply things to the old agency, you have to save those loans, creditors, and say that the new agency will pay them.
Yes. Thank you, Prof. So you save their job. For the contractors, you save their existing contract. For those the agencies are owing, you save their existing outstanding credit, which is liability of the agents. Then you transit, you carry all of them over to Agency B to say this staff, their employment is hereby saved, the assets and liability of these agents are hereby saved, and the liability includes any money they are owing anybody. You transit all of them to the new agency. Now, this is very, 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 very important. It is not what you can mistakenly forget to do, because it has far-reaching consequences. If you do not save the employment, if you do not save the assets and liabilities, and transit them to the new agency, it means that the new agency is coming on board with no singular staff. the agency cannot run itself. It also means that the agency has no assets. Yes, while it might mean that it also has no liability, it means that people who have worked can no longer get their payments under a new agency. So you can see the ripple effects. Because once you bring it up, the agency will say we have no liability, we don't owe you anything. Look at our Establishment Act. Nothing was transferred to us. We did not inherit any responsibility or liability from the previous agency. Now, that will be a very serious a very bad case of bad drafting, and it's going to have a long legal battle in court. Is liable to pay for the jobs that were done for the old agency. So you see that you, as we have said, that every legislative drafting brief you get is a problem that you have been told to provide a solution. So you cannot, in a bid to provide a solution, now worsen the problem. So please, when you are drafting your final provisions, you ensure that these clauses are all intact, and that is why I would suggest it is not a Prof didn't send me to do this, but I will tell you, you need to get legislator. Why? These headings are already there, so it serves as a checklist for you. In fact, if you are using legislator,
Hello, Ebenezer, your mic is, we're not hearing you.
if you have not filled any column, it won't allow. If you are not done with your principal provisions, it won't allow you to go to your miscellaneous provisions. If you have not completed
Ebenezer,
your
you have to
miscellaneous, it won't
start
allow you
over
to
on
proceed to your
legislator.
final provision.
Your mic broke
So
off.
we look at what are the importance. Sorry, sir. Can you hear me now?
Yes,
Is it
but you
clearer
need
now?
to start from
Hello?
legislator again.
Hello, can you hear me now?
All right, let me continue. We developed a drafting app called
So
Legislator.
I'm saying that why yes sir, yes, Prof. So I got that. So I'm saying that why this is not a marketing gimmick, but it is important if you want to draft well. Okay, I think there's a clash. So I was saying that if you want to draft well, for now as you're starting out, and you do not need to mix any of these clauses, all the clauses here are very important. All it does for you is to provide a space you fill in, so that for if you're using legislator, it will not allow you to skip any of the stages. You cannot forget any clause if you are drafting with legislator, because legislator will not allow you to move to principal provisions if you have not completed drafting your preliminary provisions. It is until you have filled all the preliminary provision clauses that it can permit you to proceed to principal provisions. And until you are done with principal provisions, that it can permit you to proceed to miscellaneous and then to final provisions. Legislator with legislator, you cannot omit any clause. So it is important that you get one for yourself, particularly those of you who are already established in this field or want to make a career out of a legislative drafting. Okay, there's a question, Madam Shetak, let me attend to that question. How much is legislator and how can one go about getting same? Okay, you discuss with Prof, you send a message, you send a WhatsApp, and that will be done. Not just getting it for you, we can get for your establishments, come and train your people on how to use it. So that it makes, Madam said that your office needs it to seriously, so that it makes drafting easier for all of you and faster too. Not just that, legislator has precedents, is loaded with precedents, one, is loaded with over 225 laws that has been passed between 2015 and today. Then our LFN complete is loaded in legislator. So what it means is that you have all the existing laws in Nigeria sitting before you. It provides you easy access to cross-referencing. You want to check what is done here, you want to check what is done here. You are working on this session and you feel that there's an existing law that this might affect. So we are talking about consequential amendments and we are talking about repeal here. So it helps you to network between all the relevant laws to know where your consequential amendments can apply and know where your repeal can apply, so that you don't end up making laws and you have conflicts in sessions, such that if someone comes to court and relying on this law, the opponent is also relying on another law that is still in force and is bringing conflict. So that is what legislator will help you to achieve. Now, what are the importance of final provisions? Why final provisions? Why is it important? One, clarity and certainty. Final provision provides clear understanding of how the new law interacts with the existing law and when it becomes effective, minimizing confusion. I just cited an example now. So you do not have a case where an existing law conflicts with a new law and both of them are equally enforced at the same time. So that is why your final provision is important. If a new law is coming in, and an already existing law that is going to clash with the new law must either be amended consequentially or repealed entirely. Two, administrative efficiency. They empower relevant authorities to implement the legislation through regulations where necessary. Now, we have done savings and transition. What it means is that the staff that were already in existence, that already have the technical know-how, that have the capacity to work, will continue to implement this new law without creating a gap, without creating a vacuum. So the new agency does not have to go searching or begin recruitment afresh to now come and train the new staff so that they come to know how the new law will apply. No, you already have capacity on ground. So what what final provision does, administrative efficiency. Through savings and transitional provisions, you have intact an already trained and capable manpower to continue the administration of the agency. without any gap. Legal consistency is the third reason why we should have final provisions. By explicitly stating which previous laws are repealed, they avoid conflicts and unintended consequences. Mark the word unintended. It was never the intention of the drafting person to bring about confusion. But where your final provisions is not done excellently and diligently, the unintended consequence might be confusion, where you have conflicting laws in operation because consequential amendments and repeals were not properly done. So legal consistency helps us to avoid conflict of laws and unintended consequences. Then we talked about the subheadings under this, but for purposes of emphasis, you have savings and transition or transitional clauses. These may also be placed in the schedule if they are long. Yes, we'll talk about schedule after now. Repeals. Laws that are outrightly repealed be presented in a tabular form. What else do we have in our final provision? Schedules. Now, what are schedules? You always hear Schedule 1 of the Constitution, Schedule 2, Schedule 3, Schedule 4. What are these schedules? Now, a schedule is a listing, but you do not just list because there is need to use schedule. It is when the items you are listing is numerous. You instead of putting the realization and maybe subsection 2A is that list, and that list runs into 3, 4, 5 pages because it's a long list, or the whole list is the entire item listed are 2 pages. Now, that such a long list, you banish them to schedule. You make it as a schedule. So you just make reference to the schedule in your session. For example, if you are listing local governments in Nigeria, 24 local governments in Nigeria, you cannot make such a long list of all the local governments in a session. No. So you make reference to the schedule in a session and now direct your reader to go to the schedule where this list is contained. It makes your work neat. It makes your work less clumsy. It makes your work well organized. So that is part of your final provision. Don't take such a long list and put it in your principal provision as a schedule. You don't take such a long list and put it in your miscellaneous provision as a schedule. So the most appropriate place to keep such a long list is in your final provisions. I have some, okay. Proverbs is sent in an example here. It says in the Pensions Act 2004, the old scheme of payments of gratuities was saved and transited to the new law, which introduced the contributory pension scheme of 7.5% by each staff. So, what this means is that, assuming there was no savings and transition, the new pension law, we have to give us, to operationalize that law, we have to look for an entirely new or different payment scheme. And that will lead to confusion. But because the old payment scheme has been transited, so you retain it automatically. Whatever you are introducing can be in addition to what is existing, but you already have a foundation upon which to build. So, any question so far? Any question on final provision? Any question on final provisions? Any question? Honorable Kolade, good afternoon. Welcome, sir. Ajulo, good afternoon. Abdul Karim Mustafa, good afternoon. I'm looking out for the people who owe us introduction. Abdul Karim Mustafa falls under that category. Yes. Hello, Mr. Abdul Karim Mustafa. Good afternoon, sir. Hello, Mr. Mustafa. Good afternoon. Can you hear me? Hello, Mr. Abdul Karim. If you can hear me, kindly introduce yourself to the class and where you are joining us from. Thank you. Okay, Mr. Ajulo, your hand is up. Kindly ask your question. Hello, Mr. Emmanuel, your hand is up. Ask your question. Wow. Please, can anybody hear me? Hello, Mr. Emmanuel, ask your question. Wow.
Hello, sir. Please, can I ask my question?
Yes, I have been saying ask your question. Proceed. Ask your question. Ask.
Thank you very much. The network is failing at my end here, at my side here. Thank you very much, sir. My question is two. The first one, I would like to
Okay.
ask that this miscellaneous provision, sir, I want to ask for the new provision, a new bill that is being proposed, and for the first time in the history of the legislative drafting, such as, for instance, the widowhood bill of 2023, which is going to be a new one. I just cite that one as an example, sir. These miscellaneous provision, are they necessary in providing, in making available into that
Yes.
bill? Why? The reason why I ask this
Yes.
is that you look at all the features of the miscellaneous. They are new. They look as if they are not necessary. But since you said that it's provision that's necessary, because you see the saving and amendment. You know the bill that is still coming, that is just coming to existence. So what are they going to be amending or
And
saving? That
transition.
is okay, sir.
Yes. Beautiful. That's a very brilliant question. Please ask your second question so that we take the two together. Hello, can you proceed with your second question? Hello, Mr. Julo. Okay, let us take the first question. We said these are the things that are under widowhood bill. Now, we talked about consequential amendments, not just a list and institution. Now, if there is an existing law already, amendment must not be on the title. Please, when you are drafting, part of your research is to check whether there is any law that will be in conflict of what you are about to draft, or will be in conflict with what you are about to draft. If you come to final provisions, for example, using that Willowwood bill, you check on all the laws that affect women. Is there anything in any existing law that may be in conflict with what you are talking about now? Then you check, because we are saying a person in employment. So you go and look at the Workmen's Compensation Act. You go and look at different labor laws and see whether there is any clause in that bill or any section in that bill that might be in conflict with what you are about to draft. Willowwood bill is saying that somebody who has lost a person should be given a number or a period of time, 3 months, to sit at home and plan for the burial of his loved one, or 6 months to sit at home and plan for the burial of his loved one. Then you look at what does the labor law say. How many days are you supposed to attend or come to the office before you are entitled to salary at the end of the month? So you now see that there might be conflict here. So what you now do is you say, notwithstanding the provisions of so and so labor law. Do you get it? That it will not apply here, notwithstanding that provision that says you must attend to work, you must come to the office before you are entitled to salary. Notwithstanding that provision, that somebody, a beneficiary, a widow or a widow, shall be entitled to his monthly salary while observing the period he needs to stay at home to plan. You see that there's already a conflict. In the alternative, you can say that for the purpose of applying this widowhood law, that section of the labor law is hereby amended or repealed. It will not conflict with this law. As far as this law is concerned, the section that requires you to come to work for 24 days in a month, or 15 days or 18 days before you are entitled to salary will not be applicable. That is on one hand. You check different laws. You check Workmen's Compensation Act. What does the law say in terms of your remuneration and that you must come to work? You check it. Then you ensure that there is no conflict between that one and this. So the fact that a new law is coming into existence or is about to be enacted does not automatically mean that it will not have conflict with an existing law. That is where your research expertise comes in. Before you draft, that is where you now do cross-referencing to check this law. How does this? No law stands alone. If you are a good drafter, you do not draft in isolation. You do not look as I'm drafting this law, it is just coming into existence, it will not conflict with any existing law. That is not true. That is where your hello, Mr. Julo. Are you still here? Can you answer? Can you ask your second question? Did my answer satisfy you?
Thank you. Thank you very much, sir. My second question goes to the prof, sir. When prof was making explanation concerning some certain provisions then
Yes. Have you had your second question?
yes, you made mention of Nigerian's ICPC law, that it is of two nature. So, sir, please, is the second one amendment, or is existing simultaneously with the second? How come we have a two law in the ICPC, sir? Thank you, sir.
I said it happened because the draft.
Two laws in ICPC.
It happened because the drafters did not, when they were drafting the final provisions, the first ICPC Act was passed in the year 2000. The second one, 2003. So when the ones of 2003 were drafting, when you get to final provision, ideally, you're supposed to look at all the existing laws. Nigeria has 552 laws. You're supposed to look through all the 552 to make sure that none of the existing laws is in conflict with the law you are drafting. They did not look, so they did not know that in the year 2000, a law on ICPC had been passed. So they passed this second law. So we now have two ICPC laws, which lawyers are using to the advantage of their clients. That is why EFCC is much stronger than ICPC.
Well understood, sir. Thank you very much. Thank you very much, sir.
Ebenezer.
Any other question, please? Any other question? Any other question? Okay, in the absence of any question, we'll be coming to the end of today's class. Anyone who is interested in legislator should get in touch with Prof for the details and how you can get it, the price and everything. Kindly get in touch with Prof for that. Thank you very much, and do have a wonderful day. Goodbye, everyone. Thank you.
Thank you.
Mr. Ebenezer and Prof, thank you very much, sir. God bless you both.